Well, good morning, good afternoon, good evening to you wherever you are in the world. If you're dialing in live to our program today, thank you for spending a little bit of time joining us here on Mina Partners Insight series of webinars. And we're very excited today to be talking about relatively recent development. As many of you in the privacy space know, New Hampshire recently became the 15th state to pass a comprehensive privacy law. This was passed by the Congress in New Hampshire, signed by Governor Chris Sununu on March 6th of last year and went into force January 1st of this year. So really pretty new for the state of New Hampshire. And we're really pleased and thankful to have with us on the program today, Warren Cormack, who is the Assistant Attorney General at the New Hampshire Department of Justice. Warren, I'm going to ask for you to tell us a little bit about yourself in just a minute, but I also wanted to make mention of the fact that very thankful to be able to be joined today by my colleague, Wills Catling, who's also a director here at Mina Partners. So welcome, Wills, and thanks for taking a little time with us today. So Warren, can you tell us a little bit about both your background and also a little bit about this, what was a bill and now has become a law and how it kind of came to pass?
Sounds great. Thanks for having me, and thanks everybody for being in attendance. So I've been working in consumer protection for over 3 years now. I was brought on to lead the data privacy unit in the New Hampshire Department of Justice this past October, and that unit's housed within the Consumer Protection Bureau at the Department of Justice. And so we have been enforcing the law as of this past January. And so I just need to give a disclaimer before I get started here. I can't give legal advice or endorse any specific method of complying with the statute. And if you have any questions about the statute, you may want to contact a private attorney or review the statute itself. The New Hampshire Department of Justice has published some FAQs that are online. So that's another resource that's out there. So the statute went active on, as I said, January 1st, 2025. There were two bills that were passed. There's SB 255FN and HB 1220FN. And so those both formed what is now the New Hampshire Data Privacy Act. And New Hampshire's Data Privacy Act follows the Connecticut model. So it's pretty similar to other state laws that are out there. And we also have a compliance with other law provision. So if there's a conflict, if different laws conflict and an entity is following the more protective law, then that is, they're following that provision. So it would be in compliance. Mm-hmm. And there are a few highlights of the act. The act created new consumer rights for New Hampshire consumers. These rights include the right to confirm processing, access data that an entity holds about the consumer, correct inaccuracies, delete personal data, obtain a copy of data, and then opt out to targeted advertising and sales of data. So these are pretty standard rights that a lot of the acts are having nowadays. There are other requirements like certain inclusions in privacy notices, certain requirements for contracts between controllers and processors, data security practices, and then there are other requirements for sensitive data as well, including requirement for consent, 15-day withdrawal of consent, and then a 15-day compliance with that. And then also data protection assessments for data that has a heightened risk of possible harm. So those are some of the highlights of the act.
Yeah, terrific. Thanks, Warren. That makes a lot of sense. And as you mentioned, it mirrors somewhat some other state privacy laws, for instance, Connecticut. So for those of you that are listening that have set up your, developed your notices and set up your systems to be able to comply with those other state privacy laws in terms of consumer requests, access, deletion, no further do not sell, etc. You should be in pretty good shape with having those systems set up. Is there anything that's unique or distinct to the New Hampshire law, Warren, in comparison to other state laws that should be highlighted here for people that they really want to pay attention to? Any nuances or anything particularly unique?
It doesn't carve a lot of new ground. I highlighted the compliance with other law. That's perhaps a little bit different from other statutes that are out there. Mm-hmm. Our statute's enforceable, as many states are, through the Consumer Protection Act of New Hampshire. That's RSA 358A. Mm-hmm. And so our New Hampshire 358A has different penalties that are worth noting. including $10,000 penalties, possible criminal penalties. But those are perhaps the two more notable things that make New Hampshire a little bit different. But it's carving a lot of similar ground, a lot of similar exemptions, a lot of similar rights, a similar appeals process as a lot of other states.
Yeah, and we should probably call out that the in terms of scope, the threshold is relatively low. And I was reading that's probably due to the fact that New Hampshire is a relatively small state. So, but that is something that people want to be aware of, right?
Definitely. I think that the per capita threshold might be more in line with what we're seeing in other states, but it is a 35,000 New Hampshire consumers data process within the prior year if the entity isn't deriving 25%, at least 25% of their revenue from data sales. If the entity is, then that threshold drops down to 10,000.
Yeah. And one other thing to note, and then Wills, I'm curious to hear what you might want to ask about in terms of the new law, is the 90-day cure period. Personally, I think it's really great that the legislators saw fit to add that in there. It gives companies a chance after being notified of a potential violation that they have some time to be able to rectify the issue and get back to you. Can you talk a little bit about that, Warren, like what that looks like and how that might work?
Definitely. So it's a 60-day cure period. It's active.
Excuse me. Yeah.
No worries. It's active until January 1st, 2026. And so oftentimes what that'll look like is we will send a notice of violation to the business. And in that notice of violation, there will be a list of violations to cure more often than not. And that gives an entity time to comply. So there are 60 days where an entity can look at the noted violations, figure out a way to comply with our requests. And what we'll do is oftentimes we'll request that entities respond with proof of compliance by the end of that 60-day period. And we'll track that timeline to make sure that we're receiving a response. And if an entity receives a notice like this, it can be helpful to open a line of communication so that we know that the entity intends to comply. And also, if there are any questions about the notice, we can help clarify some of those requirements within that notice of violation that we send out.
So to be clear and kind of translating that, if you receive one of these notices, respond. Get back in touch right away and open that communication and ask for clarification and let the state of New Hampshire know that you're going to be working toward correcting anything that needs to be corrected, right?
Right.
Yeah. Wills, do you have any questions for Warren?
Yeah. Hey, Warren. Nice to speak to you again. My first question is, I know we've talked about, or you mentioned that New Hampshire doesn't really reinvent the wheel, and thank you for that. When it comes to state privacy laws, with I think by the end of this year, if you include Florida, we're at 20 U.S. state privacy laws. Were there particular laws when the state of New Hampshire was starting to look at drafting the Data Protection Act that you kind of feel that New Hampshire echoes or mirrors more closely than other state privacy laws?
Yeah, I mean, as I said, I think Connecticut's law is quite similar to New Hampshire's, and I think that there are other states that also follow that model. And so, that model, as distinct from, like, there's a Virginia model floating around out there. So our statute is similar to a lot of those types of states. And so that's where, I think a lot of similarities are appearing in states that are following that model.
Mm-hmm. Yeah, and then kind of following up with that, in terms of what companies should be doing to work toward compliance, Wills and I work with our clients day in and day out, and we tend to think of, the activities, the compliance activities in separate categories. There's the making sure that your notices are all up to date, that they're reflecting all of the various compliance requirements for not only state, but federal and even international laws. So whatever that public notice is accurate and up to date. And then there are your actual abilities to have processes, policies, and procedures in place behind the scenes to be able to enact consumer rights. So, do you have some kind of tips for companies, Lauren, in terms of what you might recommend, how companies go about making those things up to snuff, and anything kind of lessons learned in the time that's happened? Understanding it hasn't been a long time since January 1st, but whatever your office has seen come in, where some people, where you might provide some guidance for how to stay in compliance and what to kind of pay attention to.
Definitely, yeah. There's some pretty low-hanging fruit here. New Hampshire statute has a list of necessary ingredients in that privacy notice that you were talking about. So, for example, one of the called out items in New Hampshire statute is that privacy notices need to include the date that the notice was last updated. So that's just really low-hanging fruit that if you're an entity and you're seeking to comply with the statute, reviewing those delineated requirements in the Act can be really helpful. And then obviously there are other aspects of the statute. I gave a quick overview of some of the highlights earlier, but I think that another thing we're seeing is that consumers have an expectation that businesses will be able to respond to rights requests, whether a business falls within the requirements of the statute or not. So as a business expands, it might be helpful to think, I'm going to be reaching this threshold at this point in time, and so I need to start making sure that I will be compliant once I start processing the number of consumers that makes the statute apply to me. And so I think that can be really helpful for a business that is prospectively looking towards compliance as they start processing more and more New Hampshire consumers' data.
Yeah. So what I'm hearing there is if you're a heavily B2C company and you're relatively small and you're thinking, well, I don't have to worry about this too much. I'm not going to get many consumer requests, but you're growing aggressively, probably a good idea to look ahead at how you're going to be able to process those requests should they begin to start to come in volume. And Wills and I know we deal with questions from our clients all the time. At what point do we try to handle these DSAR, data subject access requests, manually, or do we start to look for some privacy management technologies like a platform to be able to help automate some of those processes so we can, do at scale? Is that what I'm hearing?
Yes. And I think, if it's something where a business is receiving only a few requests a year, then maybe, maybe they're able to comply with the timelines that are listed in the statute. But I would just note that the statute does have required timelines in order to respond to requests, in order to respond to appeals, in order to give an appeal. So we are looking that entities are complying with those timelines that are listed in the statute.
Yeah, terrific. Yeah, and it's fairly typical. The 45 days with which to respond is fairly typical across the state laws. We see that time period a lot. So just being aware that you're wherever you are in your journey, in your development journey, to make sure that you're going to be able to process moving down the road. So Warren, how has this been received by New Hampshire consumers and companies? What kind of communications have you had so far? And has it been relatively slow as you just get off the ground here, or has it been kind of surprisingly robust in terms of calls to your office, both in terms of complaints and companies asking questions and such?
Yeah, we've had a lot of interest from consumers, and we've received several complaints related to data privacy issues, and so some of those address issues that 507H can speak to, and some of them address issues that maybe other statutes that are data privacy related can speak to, but we're definitely seeing a lot of interest from consumers, a lot of interest from businesses, and I think people seem to be exercising their rights given some of what we're seeing out there. So it's something that we're a small state, but perhaps it's something that we would expect. That it's a state with a right to privacy enshrined in our Constitution. So I think that it's something that a lot of people are really aware of, and are interested in making sure that there's compliance out there for.
Yeah, turns out that Wills and I are, Wills actually is in New Hampshire, and I'm just adjacent in Maine here. So live free or die, and kind of a libertarian history of the state would make that kind of be in tune. It makes sense that people would be paying attention, if they would want to exercise their rights. So that's great. This was able to happen. So Warren, can you talk a little bit about how, like during actions investigations, what's going to be asked of companies in terms of documentation and a kind of demonstration of compliance? What will you be looking for when these queries come through?
So that's going to be pretty case specific. And, if we are asking for a specific type of thing, we probably would just make that request known by sending it. One of the things that can be helpful is having an understanding, as we were talking about earlier, about whether the statute applies. So, how many New Hampshire consumers' data is being processed in a given year? What's a business's website doing? I think that's oftentimes can be a point of oversight for some businesses. And how many New Hampshire consumers' data is it processing? And so that way, if there's an entity that falls under the thresholds that are listed in the statute, we can address that really quickly. And then if there's not, we can have a shared understanding that, yes, the statute applies and, how can we move forward towards compliance? As far as specific data formats, the statute doesn't specifically call out data formats. So as long as, the requirements are being met, for example, there's requirement for data protection assessments, and then there are specific things that entities ought to consider as they're going through that process. And so we'll just be expecting that entities are complying with what's listed in the statute.
Yeah, and we were talking about that just before going live on the show here, that that requirement about data protection assessments, and I was asking about formats because we get that question a lot. Some states have actually published templates, but you were saying that as far as New Hampshire goes, there isn't a particular format that data protection assessment needs to be in for high risk processing activities, just that it's diligently taking into account, what data elements are being asked for, what's the rationale for asking for those, how are they being processed, are they being processed in reasonable ways as related to why they were requested from the consumer, so that's just, documented in a kind of a comprehensive and accurate way, but no particular format for that is the requirement right now. Yeah.
Yeah, and I just note that the statute also does have a data minimization requirement as disclosed to the consumer, is how it's worded. So making sure that what's being noticed in a privacy notice is authentic to what the entity is actually doing.
Right. And speaking of data minimization, we always, when we're working with our clients, it's a foundational principle, and it's we always take the opportunity to be able to say that data minimization is just a key practice and principle for any company as they collect personal and sensitive information. Be aware of what you're collecting, understand how you're collecting it, where it's being stored, how it's being used, what the deletion schedule is for that, and only collect what you really need. And by doing this, you're minimizing your risk of a data breach and unintended loss of that sensitive and personal information, and also unintended usage of it that would be surprising or upsetting to the consumer to find out that their personal information was being processed in that way. Yeah. Let's see. We wanted to also talk about public awareness campaigns. Warren, how has your office thought about getting the word out about this? I mean, it's going to be you obviously you want companies to be in compliance, but they need to be aware of the law. So, how's that gone previously, and what's underway in the future for being able to get the word out to the public?
Yeah, so we started trying to get the word out. I see this being a pretty significant part of, especially in the first few months, what the unit's trying to do. It's important that not only consumers are aware that they have new rights, but also that businesses are aware that consumers have new rights. So we've been going to chambers of commerce around the state, and we also have been talking to other states about their data privacy laws and trying to coordinate to some extent with them. And we've also published a frequently asked questions page. I mentioned this earlier. It's titled Data Privacy Enforcement. It's at www.doj.gov/data-privacy-enforcement. And that page has a lot of questions that both consumers and businesses might be asking about how to comply with the statute. and hopefully can help inform anybody who's interested as to how to comply and what the provisions of the statute are. There's also a link to the text of the statute on that page, and a link to a email address if anybody has any questions or would like to file a complaint. So those are some of the resources that we've produced and published to consumers and businesses. And also, we're having meetings like this and meeting with local community organizations to get the word out about the statute.
Terrific. We'll post those links in the comments for folks if you missed those, so you can get them. And if you're listening to the recording, they're probably in the comments down below here. So two things, Warren. One is I was curious to hear that you said you do some coordination with other states. Love to hear you talk a little bit about that. Does that just kind of trying to understand what other states are seeing and what you might want to be out the lookout for, or is that actual coordinated activities whereby some enforcement actions may be actually coordinated for a particular entity that might come from multiple states, or kind of what does that coordination look like?
Yeah, so I come from a consumer protection background, and in consumer protection, there's oftentimes multi-state action is brought by many states. That's not something that I've seen quite yet in the data privacy space, nor could I say that it's something that is actively necessarily being worked on to pending investigations or litigation or anything like that. But what I can say is that we keep tabs on states and where these types of bills are passing and where the similarities are with New Hampshire. And so sometimes we have the fortune to talk about entities that are not only in New Hampshire, being that it's a relatively small space, a lot of the times an entity that's operating in New Hampshire might be operating in some other states. So just having open lines of communication can be helpful.
Yeah. And is it possible that as we roll down the timeline here, some amendments could be passed that could change some provisions of the law? For instance, reducing the cure period or the response time. Is that something that's common or that might happen? Or do you think that what's kind of set out in the law today is likely to stand for a few years?
It's definitely possible. I can't speak to, the priorities of the legislature, but what I can say is with respect to the data, with the 60-day notice period, that is going away as of January 1st, 2026. So that's something to note. In the statute as written, there are aspects that we need to consider in issuing a period after that point, but the required 60-day period is going away. As far as other data privacy bills, there were a couple of them in this recent session, but neither of them, to my knowledge, have passed. So it looks like this statute is the way it is. It may be that there are future bills that seek to modify it or add to it in the future.
Okay, so that's not out of the question. By the way, I should have mentioned earlier, but I will mention now that as we come down toward the bottom of the hour here, we only have a few minutes left. Please feel free to post your questions in the chat there, and we'll get to as many as we can in the time that we have remaining. So go ahead and post those there if you have any questions for Warren. Wills, do you have anything else that you were looking to understand about the New Hampshire state law?
I don't think so. I think Warren and I have spoken numerous times in the past, probably 6 months now, I think, Warren, at least. So, I do appreciate that New Hampshire doesn't have massive nuances away from the other state laws, which makes things a more consistent approach for organizations looking to comply. So I think, just listening to those terms, I think as an organization, it's, kind of key points for consideration are, as we always tell companies, assess where you stand. And I think it's taking a look at the New Hampshire law, making sure that, as you said, that lower threshold, understanding where, if you have in the past geo-located your program, and you haven't applied it as a kind of a broad brush across the US states, definitely take another look at, how does New Hampshire now figure into what you're doing? We'd recommend reassessing your program just to understand where there could be gaps from a compliance perspective. I think like Warren was saying, it's like if there isn't, an outreach and there is an investigation, one of the key attributes here is going to be able to show that you've got the controls in place, that you can be held accountable for what you're doing. So it's looking at your policies and procedures, understanding, when did you last update those? When were those most recently revised? I think, Dave, you talked a lot about the use of data minimization, taking a look at your data mapping, seeing that when, if you haven't done it, probably should do it. And if you have done it, taking a look and making sure again that you consider, how are you managing? What's your change management like? How are you actually adapting to include New Hampshire in everything you're doing? And I know a lot of companies use technology for, like you talked about, data subject rights, etc. So it's ensuring that if you hadn't turned on New Hampshire and you have made the determination that you need to, and again, I think, Dave, you usually say this, but I will say it, we are not lawyers and this should not be considered legal advice. Talk to counsel for legal advice, but if counsel has said that you need to comply with New Hampshire, then make sure that you have made those changes behind the scenes so that you can comply with those data subject rights as they come in from New Hampshire residents. Take a look at your privacy notice. There should be something that's reviewed on a regular basis anyway, but make sure it's clear and concise and that it is easy for somebody to read. It's not overly legalese so that you don't confuse the consumer, and make sure that it complies with the requirements of the New Hampshire Data Privacy Act.
Yeah, some really good points there, Wills. And as we, work with our clients every day, day in and day out, you mentioned policies and procedures. Important to think about those distinctly, because policies, is documentation that you could show a regulator to say, this is what we have, this, leadership has met, this is what we've decided, how we want to handle things, how we want to manage things. We've got that clearly documented here. Having the procedures in place to be able to actually put them into play is a different thing. So making sure that you're taking care of both your policies and your procedures, and then that also your notice, what you're saying to the public that you do, matches what you are doing internally behind the scenes. So just good organizational housekeeping stuff we help our clients with every day in privacy program assessments to do gap assessments and create roadmaps for tightening up those gaps. So
yeah, Dave, as you're saying, it's like those internal controls, making sure that they're implemented, making sure that you have those policies and procedures, and then accountability, assigning responsibility and ownership for those policies. There's so often we see organizations draft a very nice policy or procedural document and then file it away, which means it's totally ineffective. And if you don't have those controls documented, how can you hold anybody accountable? Because there's nothing to hold them accountable to. So it's a bit of a yin and a yang. You need both to be able to help, raise the compliance levels of your organization.
Yeah, absolutely. And as Warren mentioned earlier, low-hanging fruit, the date of your privacy notice last updated, this is not a static process. This is an ongoing process, at least annually, if not more frequently than that. It's a good idea to revisit your policies, your procedures, your notices to make sure that everything is up to date. Things do change as we've been made aware of today. So, well, with that, Warren, really wanted to thank you very much for your time today. I know you're busy over there in the office, and we very much appreciate your coming on the program with us today to help educate folks about the New Hampshire state privacy law and its requirements. And wish you all the best as you kind of head into this the rest of this first year of enforcement, and that hopefully companies will be able to comply and safely steward consumers' personal and sensitive information. So appreciate your work out there. And thanks again for your time on the program today.
Thanks very much. And, if anybody has any questions or wants to reach out to the Consumer Protection and Antitrust Bureau, feel free to reach out to DOJ-CPB@doj.nh.gov, and then it'll be directed where it needs to go. So thanks very much for having me, and hopefully this was helpful to those looking towards compliance.
Tremendously helpful.
Thank you, Warren.
Yeah, and we'll list those links down below in the comments again, folks. If you're listening to this as live and you missed them, you can grab those. And if you're listening to this as a recording, again, they'll be accompanying the program. So with that, we're just about at the bottom of the hour. I want to be respectful of everybody's time. So we'll take us to a program close and wish everybody a great rest of the day, rest of the week, and as we head into summer here. So take care, everybody. Thanks for joining us.